Earlier this year, the Texas courts took action which effectively obliterated the current law protecting contractors from out-of-state venue provisions in their contracts. In this case, MVP Terminaling contracted with McCarthy Building for construction services around the Pasadena Terminal project on the Houston Ship Channel. McCarthy subcontracted with RLB for dredging work. The prime contract between MVP and McCarthy included a paragraph stating that the parties agreed that the contract was made in Oklahoma, would be governed by Oklahoma law, and any trial would take place in Tulsa, Oklahoma. The subcontract between McCarthy and RLB included two key paragraphs. One stated that the subcontract would be governed by the laws of the state of Texas, and another which included typical flow-down language stating that RLB binds itself to all terms and conditions of the contract documents, including the prime contract with MVP. As you may know, the Texas Business and Commerce Code includes a section that protects contractors from having to litigate claims outside of the state and under other states' laws. The code states that such contract language is voidable. This is the law that McCarthy and RLB relied upon in their case. Unfortunately, the Court of Appeals held that McCarthy waived its right to void the out-of-state venue provisions by signing the prime contract, which included the out-of-state venue language. But more importantly, the court held that the waiver by McCarthy extended to RLB through the flow-down language in the subcontract. The basis of the court's decision was the word voidable in the statute rather than void. Void essentially means it never happened, whereas voidable means that a party must exercise its right to void something. And in this case, the court said McCarthy waived its right and RLB's right to void the provision by signing the contract. So what's the moral of the story here? Be aware of what is in the prime contract. And if there's an out-of-state venue provision in the prime contract, consult with your attorney on how that may impact your subcontract.